Hello and welcome to the next instalment in our Life Science Dispute series. Today we're discussing medical device incidents and managing product liability risk. First, let me introduce you to our speakers. I am Tasmina Garaya. I'm a partner in our patents team and I work on life science disputes and regulatory matters. I'm joined by my colleagues Katie Chandler and Tim Pinto, who will tell you a little bit more about what they do.
Thanks, Taz. I'm Katie Chandler, a partner in the litigation team. I specialise in particular in the defence of product liability litigation, primarily for pharmaceutical companies and manufacturers of medical devices, and also product safety.
Good afternoon, I'm Timothy Pinto. I'm a senior counsel in the IP and media team in our London office, and I specialise in reputation and brand protection.
Our contact details are on the screen in front of you, so feel free to submit any questions that you may have. So starting off with the outline of today's talk, there are four interrelated areas that we'll be talking about today. I will give you a brief overview of the regulatory framework around incidents. Katie will then speak about inquests and High Court litigation, and Tim will speak about reputation management issues. Today's webinar is an overview, and we will be following up with a second webinar in the coming weeks where we will work through a specific example. The thing to note is these areas are interrelated. So when considering an incident, one must of course consider and deal with the regulatory compliance issues. But also, one should think about the broader issues that could arise. Say, for example, if a patient dies, inquest proceedings may well ensue. Product liability claims may also ensue. And pervading through this is reputational management issues. It's very important that in-house legal teams are engaged early in this process, and where necessary, external lawyers are brought in. So let's kick off with the regulatory framework. So many of you on this call will know that we are in a period of transition. Medical devices are regulated by 3 European directives. The details are on the screen before you, and they govern different types of medical devices. In May 2017, 2 new regulations came into force. The details are there. One is dealing with in vitro medical devices and the other on other medical devices. We are in a period of transition, and the first of those 2 legislations, the MDR, Medical Devices Regulation, will be coming into application in May 2020, so in a few months' time. There are some questions about whether that time frame is going to be met. For example, the infrastructure is not quite in place yet, and there are issues around Class 1 medical devices as well, and compliance with the framework, and also whether there is enough notified bodies that can deal with issues. But the focus of this talk is not going to be on those 2 regulations. I will be doing another webinar on those later in the year. What I'd like to focus on is the framework under the directives, because those are the incident reports, the field safety corrective actions that you may be taking now or in the near future will be governed by those 3 directives. So vigilance requirements are mandatory for manufacturers of medical devices. And manufacturers are required to notify national competent authorities of incidents and field safety corrective actions. As you all know, the relevant competent authority in the UK is the MHRA, and reports of incidents occurring in the UK are made to the MHRA. An incident is essentially a malfunction or deterioration of the characteristics and or performance of a device, as well as the inadequacy in labelling and instructions for use, which, and these are the key words, which might lead or might have led to the death of a patient user, or serious deterioration of their health. There is a third type of reporting as well, trend reporting, where there is a significant rise in events that are not typically qualify as a incident. However, I'm not going to go into too much detail of those. There is a lot of guidance on this, particularly in the MedDevs in the form of MedDev 2.12. So the criteria for reporting incidents is briefly set out there, and I will go into a little bit more detail about them. So an event has occurred. The manufacturer's device is suspected to be the contributory cause of an incident, and the event has led or might have led to the death of a patient or other user or other person, or serious deterioration in the health of a patient, user, or other person. And there are also some limited exceptions as well. So conditions, and these are also set out in the MedDev, conditions where reporting is not usually required. So, quick overview of these criteria. An event has occurred. The MedDev gives several examples. It's a non-exhaustive list, which are set out on this particular slide. So, malfunction or deterioration in the characteristics and performance of a device. In respect to IVDs, in vitro diagnostic devices, where the device leads to a management decision, a patient management decision, which can cause death or serious harm to the patient, erroneous results which could lead to, say, the death of a fetus, etc. Unanticipated adverse reactions and unanticipated side effects, interactions with other substances, degradation and destruction of a device, e.g. fire, inappropriate therapy, and also the inaccuracy in labelling instructions for use and promotional materials. So when going through the analysis, an event has occurred. The second criteria is a causal link. The device is suspected to be the contributory cause of the incident. So when assessing this, manufacturers may consider the opinion of healthcare professionals, taking into account available evidence, results of preliminary assessments of the incident, evidence of previous or similar incidences, and other evidence held by the manufacturer. Now, this raises interesting questions in terms of privilege, for example, of these documents, or any reports, internal investigations that a company has done. And Katie will be touching on that later in the talk. The event must also have led to, or might have led to, death or serious deterioration in health. Serious deterioration in health includes the list that I've set out on the screen before you. These are in the MedDevs as well. It's important to note that the events do not necessarily have to have happened. It's sufficient that the incident is associated with the device itself, and there is a risk that if it happened again, it might lead to death or serious deterioration in health. As I mentioned, there are some exemptions, limited exemptions, and again, they are set out there. For example, the device is being, or the deficiency has been discovered before use. Say, for example, that a syringe, a sterile syringe, which has come pre-wrapped, has a note on it saying do not use if the packaging is damaged, and a nurse or a doctor or other healthcare professional has noticed that before use. The event has occurred or has been caused by patient conditions. For example, there's a natural deterioration of the health of that individual, which is unrelated to the device itself. The device has been used beyond its shelf life or service life. protection against a fault functioning correctly, as the device functioning correctly, expected or foreseeable side effects, and that's subject to conditions set out in the MedDev, negligible likelihood or occurrence of death or serious deterioration in the state of the health. And now, when you're actually using that criteria in your analysis, manufacturers will need to do a risk assessment, and it has to be a full risk assessment, taking into account the relevant factors. And so when relying on that particular exemption, it has to be justified. It's not acceptable to say, oh, because one person has suffered this particular issue, it's not a major issue. One has to perform that risk assessment. And abnormal use as well, where the patient or a healthcare professional, for example, has not used the device in accordance with the manufacturer's instructions. How are incidents reported? If it's an incident, it's usually to the national competent authority in the country of occurrence. So in the UK, the MHRA. Who reports? The manufacturer or the authorised representative can report directly to the MHRA in the UK using the manufacturer's incident report form. That was updated on the 1st of January 2020. It does contain new sections dealing with the MDR, the Medical Devices Regulation, which is in transition at the moment. It's submitted to the MHRA using the MORE platform, the manufacturer's outline reporting environment. It's also important to note that members of the public and healthcare professionals can also report directly to the MHRA using the yellow card scheme. And the interaction there with the use, say, of social media is also interesting, and Tim will pick up with that. For example, if a user has had an issue with a particular medical device, they may go onto social media or may approach a journalist about that particular occurrence. So reputational management issues might come in at that point as well. And also at that stage, where a healthcare professional or a member of the public has reported directly to the MHRA, the manufacturer may not be aware of that until a little bit later when the MHRA contacts the manufacturer about that particular event. And when to report, the timings. These are very important. So under the medical devices guidelines, under the MedDev, it's in the case where there is a public health threat, a serious public health threat, the report must be made immediately, and immediately means without delay. That cannot be justified, and no later than 2 days since the awareness of that particular event. Where there is death or unanticipated serious deterioration in the state of health, again, that's immediately without delay, and no later than 10 calendar days since the awareness of the event. In other cases, it's immediately and no later than 30 calendar days of awareness. If you are in doubt, the default is to report. Thing to note there is in the case of the other, sort of the long stop date of 30 calendar days changes under the Medical Devices Regulation. That becomes shortened to 15 days, 15 calendar days. The form of the report that is submitted. The report does not have to be in the final form when it's submitted to the MHRA or another competent authority. The manufacturer submits an initial report. And within that report, the manufacturer specifies when they will update the regulator. So follow-up reports and eventually a final report with any corrective actions that may have been deemed necessary. So the manufacturer is engaging with the regulator. The regulator may also provide feedback in terms of the timings of the next reports, etc., and also the corrective actions that are proposed by the manufacturer. In terms of liability, and this is purely from a regulatory perspective, the report, the MedDev makes clear that the report is submitted without admission to liability, and the manufacturer can put in disclaimers that the submissions are made without prejudice to any cause or any link or any admission as to liability. And again, Katie will touch on that in the context of litigation. Internal investigations. So when a manufacturer is going through this process, they have to do internal investigations. They can access the device if they need to. However, if they change the device in any way, so the device in question, they may need to contact the regulator to tell them and to let them know that that's what's going to happen. The manufacturer performs the investigation rather than the regulator, for example, conducting a root cause analysis. The role of the MHRA or the regulator, the competent authority, is to monitor the investigation, the progress of it, the conduct of it. They can intervene in certain cases, say, for example, they disagree with the plan of action by a regulator. The outcomes of submitting a report could be no action. Again, that has to be justified and has to be supported in the reports that are made. The product may require, or the device may require, additional surveillance. There may need to be changes to the manufacture of the device going forward, or there may be a field safety corrective action, a recall. So turning to inquest proceedings, I'll hand over to Katie.
Thanks very much, Taz. Yes, product liability claims arise in relation to a wide range of products, but there are an increasing number of high-profile large group actions against medical device companies in the UK. There's been the group litigation arising out of the PIP breast implant scandal, the metal-on-metal hip implants, and the women involved in the vaginal mesh implant litigation. And what you often find is that there will be an incident report and a regulatory investigation. It may unfortunately result in inquests and then follow on product liability claims. So I thought I'd just talk about briefly the inquest proceedings process and then move on to talk about the product liability regime. So what is an inquest exactly? Well, it's important to note that it's a fact-finding process to investigate the circumstances of a death, the who, how, when and where the person came by their death. The coroner's duty is to ensure that the facts are fully and fairly investigated. They're not there to determine any civil or criminal liability. It's primarily an opportunity for lessons to be learned to ensure the prevention of future deaths. The standard of proof is to determine the cause of death on the balance of probabilities. The inquest is held without a jury unless certain circumstances are met, such as a death in custody. And the coroner must invite those parties that have a sufficient interest, and particularly those organisations who may be the subject of criticism. So manufacturers of medical devices linked to a cause of death will likely be invited to be an interested person in the inquest. This means they would participate in the hearing, provide and have access to disclosure, give witness evidence, both oral and written, and ask questions of a coroner-instructed expert and other witnesses. As I said, it's inquisitorial, not adversarial, but for a corporate involved in an inquest, there are two real main concerns. The first is reputation management, and Tim will touch on this when he talks, and the prospect of a civil claim. And the two often go hand in hand, but just because there's a prospect of a civil claim doesn't mean that you should be adopting an adversarial approach or try and turn the process into a trial. If you are involved, it's far better in our experience to be cooperative, open and transparent. But there are pros and cons of participating as an interested person, and these need to be considered at the outset with legal advice. It can depend on the circumstances involved, but generally speaking, if you're involved, you can have some control and influence over the process. But we have also acted for clients where we've advised not to become an interested person, and particularly if you're based outside of the jurisdiction and the powers to compel witnesses and involvement are more limited. So the coroner does have a wide range of powers, powers to compel witnesses to give evidence, to produce documents, to inspect or examine or test the product. And the witnesses can be asked to give oral evidence at the inquest itself. This may actually be evidence on the internal investigations, the type that Taz has been talking about, or any changes, corrective action that has been made since the death in the prevention of future deaths. This requires preparation and assistance from a legal team in order to get the tone right, to protect the manufacturer's interests as far as possible, while also cooperating in a fair and open manner. You know, who should give the evidence? Will it be a senior member of the organisation, a board member? Are failings going to be recognised and accepted, or will potential criticisms be rejected? Will there be an apology? Will that be made without prejudice to the legal position and without any admissions? All of these matters need to be considered when considering the extent to which you are going to be involved and giving witness evidence. Rule 22 of the Coroner's Inquest Rules 2013 does prevent the self-incrimination of a witness, and so a witness is not obliged to answer any questions whilst giving evidence tending to incriminate him or her. As to expert evidence, the coroner is really responsible for calling the relevant expert witness. They have discretion as to whether to call one or not. You might see a pathologist, a toxicologist, or a specialist in a particular field relevant to the potential cause of death. There are pros and cons for instructing your own expert and at what stage of the inquest proceedings you do this. It might be that you want to do it at the earlier stage so you can be fully conversant of the issues and potentially assist the coroner and guide and influence the way in which their expert looks at the issues. And you might be able to make written requests for specific questions and an answer to be provided. But there are, of course, disadvantages, as this could highlight particular difficulties in your case at an earlier stage. But instructions to the expert and any written report may also need to be disclosed to the coroner. So privilege issues also become relevant. It's unlikely that the coroner would instruct your expert at the risk of appearing partisan, but your expert could give evidence at the same time and questions could be asked of both. And there's also an overlap between the regulatory investigation, the incident reporting process that Taz described, and the inquest proceedings themselves, and that needs to be carefully managed. It can often be the case that the medical device manufacturer is engaging with the MHRA on the results of its risk assessment, the outcome of its root cause analysis, while also being an interested person in the inquest. So it needs to be noted and assessed as to how the coroner and the regulator are liaising with each other, who is leading any particular investigation and who has conduct of testing of the product. And also, will the coroner wait and see whether the regulator enforces any corrective action or field safety notice before reaching their own outcome in the inquest? Where a manufacturer submits an initial incident report at the outset, this can help gain the confidence and trust of the coroner. The two processes can run hand in hand, so it is essential that you seek legal advice on how to manage both. The outcome of an inquest, the coroner will give a legal determination, which will state who died, when, where and how, and gives findings to allow the cause of death to be registered, for example, accident, misadventure or open. As I said, there'll be no findings of civil or criminal liability. The coroner can give narrative reasons for conclusions on the circumstances of death, which may refer to certain failings or issues raised during the inquest, which would need to be investigated by those involved, such as the manufacturer of a medical device. And even if the coroner hasn't engaged with the MHRA during the inquest process, the coroner can then notify the MHRA once it's made the legal determination and found any findings or any issues relating to potential safety hazards. So moving on to product liability claims, which do often follow from an inquest hearing. These can be brought against a manufacturer for a medical device in three ways: strict liability under the Consumer Protection Act, which implements in the UK the EU Product Liability Directive; negligence for breach of a duty of care, a manufacturer of a medical device will owe a user a duty of care; and in contract. Generally, it's easier for a claimant to establish a claim under the strict liability regime of the CPA, as no fault is required or any breach of any standard of care. Claims in negligence are still often pursued at the same time, particularly if there are any limitation issues or you want to obtain more extensive disclosure and have a more evidence-based gathering exercise. As I said, in negligence, a claimant needs to show that the manufacturer owed a duty of care, that duty was breached, and the breach caused the damage of a type that was foreseeable. For product liability claims, this usually doesn't cover financial loss that doesn't arise from damage to property or physical injury. Claims are often brought against the manufacturer directly, but sometimes liability can pass up through the supply chain and include importers, distributors, or any other party putting their mark and presenting themselves as the manufacturer. In negligence, one of the key defences is contributing negligence, where the claimant's own actions may have contributed to the loss and can result in a reduction in the amount of compensation, or voluntary assumption of risk, where the claimant knew of a risk of a product and chose to accept it anyway. Liability in contract depends on the terms of the contract, although you should be aware of the implied terms for satisfactory good, fitness for purpose and conformity to description under the statutory warranties in the Sale of Goods Act and the Consumer Rights Act. And I think one important point to note on the English product liability regime is that it's just not similar to the US regime. There is no punitive damages concept. The usual remedy is damages to put the claimant back in the position they would have been had the loss or the injury not occurred. And this often involves claims for loss of earnings, medical expenses, loss of amenity and specific compensation for the injury in question, which is usually made with reference to the judicial guidelines which are published by the Judicial College. So moving on to strict liability under the Consumer Protection Act, what products are covered? Well, the definition of a product is very wide. It means any goods and also includes those comprised in another product. And that's included transfused blood, sort of a whole range of products. There's also currently a debate about whether or not software, and particularly software as a service integrated into a device, is a product. So that raises interesting questions for advancements in medtech in particular and the medical Internet of Things. This is currently remains under review and in debate. And who is liable? Primarily it's the producer, who will be the manufacturer, but an own brander or a party using the trademark can also be liable. And when is it considered that a product would be defective? Now, this is a question of fact, and the parties will usually rely on witness statements and witness evidence or expert evidence where relevant, particularly scientific and technical evidence, and perhaps state-of-the-art evidence to support their positions. But under the CPA, a product is defective if it is not as safe as the persons generally are entitled to expect for the intended use by reference to all the circumstances. All the circumstances means a number of things, and in the statute itself it refers to how the product is marketed, its get-up, the use of any mark in relation to the product, and instructions and warnings, including the patient information leaflet and any warnings on the packaging. As I said, it is very fact-dependent, but there have been a number of key decisions, and more recently in the cases of Wilkes and Depew International and G and Depew International Limited. These decisions have previously have criticised previous judicial approach as to what the legitimate expectation means. And the test now seems to be that the level of safety shouldn't be assessed by reference to actual expectations of a group of particular individuals, but when considering whether a product suffered a defect, the court has to assess objectively the appropriate level of safety, exercising judgment and taking into account the information and circumstances before it, whether or not actual patients would have considered each of those factors and all of that information. It's also important to note that the court is aware that certain products are inherently risky or dangerous, but not necessarily defective. There has to be a risk-benefit analysis. No medicinal product, if effective, can be entirely safe. Safety is inherently and necessarily a relative concept, and potential benefits of a product have to be balanced against the risk. Also, there's an express provision in the CPA which states that a product will not be defective because a better, safer product is subsequently put into circulation. But liability is strict, and there is no requirement to prove the manufacturer was at fault in causing a defect. The claimant only needs to prove that the defect existed and there is a causal link between the defect and the harm caused. And it's not necessary for the judge to ascertain precisely what caused that defect. The recent cases have also emphasised the relevance of the question of whether a product is defective if it meets relevant safety regulations. And the current view is that it would be difficult for a claimant to prove that a product was defective if it does comply with the relevant regulations. But that is not an automatic defence under the CPA. But the evidence at the level of safety is that which persons generally are entitled to expect, and one would think that that goes some way to establishing that. So what are the defences under the CPA? Well, in the interest of time, I'm just going to focus on one, which is the state-of-the-art development risk defence, and often deployed by manufacturers of medical devices, although it has had narrow application and limited success, unfortunately. But what it means is that there must have been knowledge of the risks which caused the product to be defective, and the state of knowledge at the time is considered on an objective basis. So the focus is on scientific and technical knowledge that was available at the time as to whether or not those risks could be known. This is scientific and technical knowledge as opposed to industry practice and safety standards. and it must be identified by the most advanced level of research, not just the majority of opinion. And also the type of scientific research is relevant, and the accessibility of the journals. So, for example, a study of an American university published in an English language journal, would have a wider application and wider knowledge than, say, for example, one that's in a local scientific journal in Chinese and doesn't go beyond the boundaries of a specific region, for example. But as I say, it's a limited defence, and there is a high threshold to be met. Another point to note is around class actions. As I said, the regime is different in the UK as to the US. There is no opt-out class action regime, similar to the process in the US. The English courts have a power to permit the management of group or collective actions. The court can order that claims with similar issues of fact or law are dealt with together under what is known as a group litigation order. As I mentioned, some of the more high-profile, well-known product liability litigation against pharma companies has been pursued in that way, but it is an opt-in mechanism. The claims remain individual actions in their own right, but procedurally they're managed together by the court for efficiency. Although the judgments and findings do not bind all of the actions, it's usually the case that there would be a test case that would be selected, and that would be persuasive and also provide guidance and assistance on the likely prospects of similar claims, which can help in assisting with early settlement. So just turning to a specific point that's relevant to the management of product liability claims, and that's privilege, and this is the legal right to withhold disclosure of documents in certain circumstances. There are two main types of legal professional privilege. You have confidential communications between a lawyer and their client for the purposes of receiving or giving legal advice, and that is protected by legal advice privilege. And confidential communications between a lawyer and a third party, or a client and a third party, for the dominant purpose of actual or contemplated litigation. These can be protected by litigation privilege. Privilege issues are likely to arise in the circumstances that we're discussing today, in the internal investigations carried out by the manufacturers, the reports that are produced to the regulator following the risk assessment, and also disclosure that's required in civil proceedings. Those documents on which you rely or adversely affect your case or can assist the other side's case. And we are aware of a number of practical measures that can be put in place that manufacturers should be aware of. And I should say that there could be an entire webinar on the subject of privilege, but for the purposes of today, I just wanted to run through some of those measures. I think when the manufacturer is carrying out the internal investigation and the root cause analysis, it's important to keep in mind contemplated litigation. So where you are producing those documents, they are being generated for the internal investigation, but what is the nature of the outcome of that? Are you going to find yourself in a regulatory enforcement action or follow-on product liability litigation? In which case, are adversarial proceedings contemplated, and are they likely? Litigation privilege will protect disclosure of communications with third parties, such as experts and those employees within the company who may not necessarily fall within the definition of the client. So some of the practical steps that we always advise on are, from the outset, and particularly with the external legal team liaising with the in-house legal team, define who the client is in the engagement letter with an awareness of how this will relate to legal professional privilege. Produce an internal memorandum, possibly by the in-house legal team, setting out the purpose of the internal investigation and why we think that potentially legal advice or litigation privilege in particular applies. Include in that definition of the client all those relevant employees that you need to speak to as the in-house legal team running the internal investigation and managing the risk assessment, such as those members of the product safety team, the technical team, the Q&A teams, to ensure that these will not be just considered employees who fall outside of the definition and therefore outside of the privilege protection. Mark all the communications as privileged and confidential, and limit documents and reports, and where possible, communicate orally. Don't disseminate any documents too widely. And key is instructing the lawyers early. Ensure that the safety issue gets brought to the attention of the in-house legal team and that they manage the investigation, and if necessary they instruct external counsel and keep them copied on all relevant communications. So my last point I wanted to talk about was just some general points on risk management. There is inevitably an impact on corrective action and recourse on litigation. It's highly likely that a claimant would claim for personal injury based on a pleading that the recall or any associated warnings or corrective action amounted to an admission or evidence of a defect in relation to a product. But that said, it will be a question of fact on a case-by-case basis, and the court still needs to determine under the CPA whether a defect existed and whether it existed in that particular product. And the court will have to determine that with regard to the available factual and expert evidence, including the scientific knowledge. A manufacturer might also want to argue that that corrective action was only precautionary. But there is a risk that the impact of potential follow-on litigation following any corrective action, and therefore that should always be borne in mind right from the outset. And then there are some other practical points to consider in terms of risk management. Does the manufacturer have adequate internal controls in place to monitor and address safety concerns? Is there a quality insurance system in place with adequate records, testing records and documents maintained, and are they easily accessible? Do they record and trace the products for supply purposes? Is there appropriate insurance in place? Now this will be product liability insurance, but also product recall insurance, and not forgetting directors and officers civil liability insurance. And is there an adequate claims handling process, a complaint system in place to monitor and investigate safety issues? Because it's essential that the manufacturer acts quickly when put on notice, as Taz described, in terms of when there is an incident. And other practical steps relate to potentially the contractual mechanisms that you have in place. Do you have the allocation of risk in contracts? Are there the necessary indemnities, the warranties, limitations of liability? How is liability passed up the supply chain? And finally, my last point I wanted to end on is just the key point, which is when a safety issue occurs, instruct the in-house legal team early, instruct the external legal team early, and where possible, follow a product safety crisis management team. I'm going to turn to Tim now, who's going to talk about the reputation risks arising out of these sorts of incidences.
Thank you, Katie. Yes, so a key thing with the use and deployment of medical devices and related products is trust. It is essential that consumers and healthcare practitioners trust the products they're using and that the products have a good reputation. And trust and reputation are closely intertwined. If something goes wrong or there are negative allegations about a product, these can be quickly picked up by the mainstream media or put on social media. The allegations could be as a result of a competitor complaint or a competitor allegation, or a regulatory investigation, an inquest, or litigation. All of these things can lead to reputational issues, and damage to reputation and trust can snowball out of control quickly. There are 3 stages to managing reputation. As we see it: preparation, and then the pre-publication stage. That's, for example, when you're contacted by a journalist, and the post-publication stage, for example, when something has been put online, say a newspaper article. So for the preparation stage, try and anticipate at this stage now what could potentially happen with your product, even if you think it's extremely unlikely. And following what we've been discussing earlier on this webinar, this could be a complaint, an investigation, a recall, injury, death, or litigation. And appreciate that time is of the essence, and I'll explain a bit more about that later. But because time is of the essence, you need to try and put together your team now rather than when the crisis happens. So if you haven't already done so, then you'll need regulatory experts and media lawyers and communications advisors. And I will explain their respective roles in reputation management a little bit later. If there's an inquest, then if it's appropriate, and if you have the opportunity, consider the pros and cons of interested person status from a media perspective. Because if your company is an interested person, that will put it more in the spotlight by putting your head above the parapet. On the other hand, as we've heard, interested persons get more access to information and have a right to make representations in an inquest. In the event of a crisis, it might be appropriate to issue a public statement very quickly, even if you don't have all the information. And you could potentially put something very basic together now, just in case, which will obviously have to be tailored to each individual event, but it could say something like, our deepest sympathies go to the family at this difficult time, and we're carrying out an investigation into what happened. But make sure whatever you say is checked with your legal team. But before covering the pre-publication and post-publication stages, it's worth looking at a few points of English media law as a bit of background. So one of the questions we're often asked if there are adverse allegations about to be published is, can't we get an injunction? Well, under English defamation law, you can't get an injunction pre-publication for defamation. What is defamation? Defamation is basically publishing false allegations that damage reputation. There are a few nuances to this, and two of which not everybody is aware of. The first thing is that for companies, something said about the company is not defamatory unless the company can prove that the allegations have caused or are likely to cause serious financial loss to the company. And that's pretty difficult to prove. That's from Section 1.2 of the Defamation Act 2013. The second thing people may not realise is that a pure criticism of a product where there's no imputation about the conduct of the company is also not defamatory under English law. So if an allegation is defamatory, for example, saying that the company has done something unlawful and therefore caused a death, then what are the defences that apply to the person that's made the allegation, which might be a media organisation? Well, the first defence is truth. So if the journalist or the media organisation or whoever it is can prove what they've said is true, then you can't do anything about it because that's a defence. Another defence is honest opinion. And courts are very protective of honest opinions, even if you completely disagree with them. And similarly, the courts are very protective of scientific debate, including about medical treatments or other types of treatment. And the case on this is the British Chiropractic Association against Simon Singh. And in that case, the allegation that Simon Singh had made in The Guardian was about promoting bogus treatments, and his opinion was based on scientific evidence. And the court said that was opinion, and this was scientific debate. The media also have a defence of publications in the public interest. So if the journalist has done enough work and his topic is on the public interest, then provided he's done that, then there's a defence to a libel claim, even if what he's saying is false. So even if you see something false, you still may not be able to stop it in the media. But the journalist has to do enough fact-checking and generally contact your company, if it's your company, to put the allegations before publication to see if you've got any comment. And that's one of the reasons why journalists do come to people before publication, because it helps them with the public interest defence. If there are court proceedings, for example in litigation or a coroner's inquest, the media has a privilege for publishing fair and accurate reports. And regulators such as the MHRA, things that they issue to the public, they'll be heavily protected as well. We have had a case where a client wanted to stop something the MHRA had been saying, but in general this is very difficult to stop. On the next slide, there's a law called malicious falsehood, and to stop someone saying something about your company or your product which is false, you'd have to prove that not only is it false and damaging, but also that the person who said it is malicious. And what that means is that they knew what they were saying was false. And as you can see, that's quite difficult to prove. But if you explain to the journalist or whoever's the publisher what the facts are about, for example, your product, maybe that it was fully compliant and had prominent warning labels, if that's applicable, then it makes it much more difficult for them to continue to publish false allegations about the product once they've been put on notice. The law of confidentiality could apply. So, for example, if you've got an NDA about something and you want to stop the media or someone on social media publishing confidential information, the NDA can be extremely useful, powerful tool to try and stop that. But it's a balancing exercise, and the courts will weigh up the rights of free speech against the rights to keep the information confidential. And in a crisis situation to do with a medical device and the problem if somebody's been injured or died is you don't want to be looking like you're trying to hide the truth or anything like that. So it's a very fact-sensitive position which needs to be considered very carefully. And then one last thing about law and regulation is that there's a regulator in England that regulates most of the mainstream UK media called IPSO, the Independent Press Standards Organisation, and they have a code of conduct which includes principles of accuracy, and instead of litigation you can get a cheaper and faster route which may or may not be appropriate in the particular circumstances by going to IPSO and complaining to IPSO rather than litigation. So with that quick overview, I'm just going to briefly mention what happens at the pre-publication stage and then post-publication. So the pre-publication stage, this for example is when a journalist has contacted your company, is absolutely crucial. This is the time when you can really make a difference, because before the article has gone to press and the journalist is still asking questions, you can, if the article is completely wrong, you can kill the story, or if there are certain misleading or wrong facts, you can get them stopped in the story much more easily than after publication. But the tricky thing is, at the pre-publication stage, is you have very little time to do that. And that's why having the team all ready to go at this stage, just in case something happens in the future, is essential. So, how much time will a journalist generally give you? Well, there's no rule of thumb, of course, and it varies enormously, but for a newspaper, a daily national newspaper, a journalist could contact you at lunchtime and ask you for a response by, for example, 5:30, which is extremely little time to work out what you're going to do, what's happened, what you're going to say, and get the team in place. And for weekend newspapers, you might be contacted on a Friday, say lunchtime or possibly even later. Broadcasters will generally give more time, so if there's a consumer protection or investigative journalist program, they might give you maybe 7 days. But as I say, there's no rule of thumb. So what are the options at the pre-publication stage? Well, one of the things is that if the journalist has said they're going to write some allegations about a defective product or someone who's died or been injured, and could you comment on it? Well, that doesn't really tell you very much at all. So one of the most important things, if you possibly can, is to try and find out what the allegations are. What are the specific things that the journalist is going to say in the article, so that you get a chance to respond to them. And your media lawyers and communications advisors can help with that. The next thing you could do is to put out a statement for publication in the article. Just remember that try to make it as succinct as you possibly can, because if you send out lots of long paragraphs with your side of the events and all about your company and your product, the media is highly unlikely to publish all of that. And you're not going to get editorial rights of approval before publication, and as I say, you'll have very little time in which to decide what to do. But if you do think that the media is going to publish something which is wrong, then you may need to deploy legal and regulatory the legal or regulatory framework to try and stop this. And that's the role of a media lawyer and a communications advisor, also known as a PR. So what's the difference between them? Well, the PR will generally communicate with the journalist, and your lawyer will generally communicate with the in-house lawyer at the newspaper. And those lines of communication are well established and very effective. Which is best to have? Well, both. That's because in different situations, the team might decide only the lawyer is going to speak to the lawyer at the newspaper, or only the PR is going to speak to the journalist. But you need to coordinate everything. In some cases, it's most effective to have both the lawyer speaking to the newspaper's lawyer and your communications expert speaking to the journalist at the same time to get the best effect. But one overriding point for all of this is truth. The media and you and your business are really interested in one thing, which is that false statements and misleading statements are not published. And so in that regard, trying to be able to persuade the publisher or the journalist that what they're saying is false, if that's the case, is usually the most effective way of proceeding. So that's the pre-publication stage. Now, post-publication, so imagine something's been put on TV or put online or in a hard copy newspaper or a journal. What can you do about it, or even on social media? Well, you can use the legal and regulatory tools I've mentioned to try and get the article taken down or amended or corrected, or to try and get a clarification published. And generally speaking, because most things are online these days, most media articles, the articles, first of all, can be updated by the journalist if you can persuade them to do that, and secondly, you want to make sure that the Google search at the end of the day doesn't give false and damaging information about your business and your products. Really that's very important, because the Google search result at the end of the day is going to last forever, whereas a hard copy probably these days isn't so important as the online copy. So, as I say, if you can persuade the newspaper they've got it wrong, then they may be prepared to update the story and make a correction. It's much more difficult to get them to issue a retraction or an apology or things like that, but as I say, every case is different. Social media is slightly different in that if somebody has posted something online on social media which is wrong and you want to try and get it removed, you may be able to do that using the tools that I mentioned earlier, but it's more tricky because, of course, if you're trying to stop an ordinary member of the public giving their opinion about something, it not only could you be trying to curtail free speech, but also it might backfire. So you've got to be particularly careful about social media postings and bloggers. But they don't get nearly as much coverage as the mainstream media in general. So that's a very quick overview of reputation management and media law in the context of medical devices and product liability. For more information, we've just published our corporate reputation management brochure, and there's a link to it on the slide and in 2 slides' time. And with that, I thank you very much for your attention and hand over to Taz to conclude.
Thank you, Tim. As Tim mentioned, we have a few resources on our website as well. So our microsite sign-ups, there is a link there if you'd like to look for further information there. We've also got our Protecting Corporate Reputation brochure and also guides and other material on our website, and our product protection blog. Again, details on the slide. So that just remains for me to thank you for your time, and do reach out to us if you have any questions or queries or would like to discuss anything further. As I mentioned, there will be a more in-depth regulatory webinar focusing on the changes that are going to be introduced by the new medical devices regulations, so watch out for that. And also we'll be having a follow-up webinar to this particular one, going through a case study, a fictitious case study, and going through the challenges of that. Another thing to look out for is the next in the series of this Life Sciences Disputes webinar series, which should be coming out in the next couple of weeks, so keep an eye for that. Thank you for now. Bye-bye.